And hello, everyone, and welcome to the Copyright 2.0 Show, episode number 349. My name is Jonathan Bailey. I am from the site Plagiarism Today and the Twitter handle Plagiarism Today, too. And joining me, now becoming a recurring thing, attorney Evan Sherez. Evan, how you doing? How's your weekend going? We're
My
recording on a
weekend is
weekend.
going very well. I know it's been a nice lazy Sunday. Watching like I was telling you, Orange is is the New Black. Been binge watching that. It's very entertaining, and everything's going well with me. And I guess I'll do my quick bit as always. Nothing I say here should be construed as legal advice. This is merely my mostly layman commentary. So if you have any legal problems, you should seek a lawyer and not rely on anything I say here.
Sounds good. Well, I gotta say, it's been a crazy, crazy, crazy week for copyright news. A lot of big stories. We'll get to them in just a second. Anything going on you want to talk about real fast? Anything you want to plug, promote? Otherwise, push out
So
there?
let's jump right into
Oh
it.
well, let's skip the fluff today and dive right in because the first story this week, not a shock, but definitely big news nonetheless. Aereo has filed for bankruptcy, and I really wish I had the soundboard so I could do the Wheel of Fortune bankruptcy sound here, but I don't. So just put it in your own head.
Well, let's skip the copyright infringement on the Copyright 2.0 show. Although
Exactly.
I wonder if they've trademarked any of those sounds yet.
I don't. That's a good question. I think that would be more a trademark issue than a copyright one, because I can make a strong fair use argument, but yeah, trademark could be an issue.
Yeah, I would agree. It's fair use. I mean, I'm trying
Yeah,
to think. Do I remember? Is it like dunna dunna? No, that's Price is Right.
yeah,
What's the
that's.
bank? what's the?
Woo!
Okay. Well, maybe
I
that may not be distinct enough to be recognizable as a
Yeah, I
trademark.
don't know. But
But
anyways,
Price is Right, people. Ben Antonello,
that's
that's your
your.
thing.
You'll
That's your
trademark that if you haven't.
get on
Um,
that.
but yeah, no, interesting here. Aereo has. I love the headlines I've seen on this. One's that Aereo gives up the ghost. Aereo collapses. It's all so mortal. It makes you. It really, and of course, we're linking to the New York Times. It's simply Aereo concedes defeat and files for bankruptcy. Which really, Aereo has not completely conceded defeat with this filing. Sort of a misheadline here, but yes, after a lengthy legal battle that went all the way to the Supreme Court, involved decisions in multiple circuits, Aereo has finally, and I say finally because they lost back in June, wasn't it? We're doing this in mid-November. They have filed for bankruptcy. They,
Right? And just in case somehow someone still doesn't know about Aereo, this is your online TV streaming service that is no longer in service that provided a little antenna and streamed that to your online services in hopes of escaping copyright
yeah,
license.
it was, you basically rented a tiny little M-shaped antenna,
That's
basically.
right. Um, So yeah, the buzzer sounded a few months ago, and the score was a blowout, and the teams are off the field, and now they've declared bankruptcy. You know, it's like
Yeah,
it's kind of like admitting you lost the game the next morning. It's been over for a while.
and it's been kind of weird with Aereo because they've kept shifting legal strategies. I mean, at first the whole we rent antenna thing, that was to avoid copyright infringement, well, avoid being accused of it because they were saying, hey, it's not a public performance, it's a one-to-one thing. One antenna goes to one person, not a public performance.
Right,
That's the argument they took to the Supreme Court and did not win with.
right.
And so then they shifted gears. Oh, we are a cable company. What do you know? Gee golly willikers, we decided we're a cable company. How about we get some of those statutory licenses going?
Yeah,
And tried that route. That didn't work. The Copyright Office and the courts didn't back them on that. And since then, they've been kind of trying a bunch of legal strategies. They have not been in service since June. They kept their staff on until I think it was a week or two ago. They let nearly everyone go,
right.
and now they're filing for bankruptcy, which this bankruptcy gives them protection from the creditors, of which I'm sure they have many. Um, but it doesn't necessarily mean they are folding as a company. They're still hanging around. They're supposedly using this opportunity to restructure or recapitalize.
Right, like most companies, when you hear
Yeah,
bankruptcy, it's very rarely means they're going away. It's obviously a last resort legal action that you can take with your company that can allow some room for restructuring. GM was bankrupt, so
Yeah.
you know,
There you go. Well put.
So here's a question I'd like to throw forward. A lot of these companies, ever since Napster was like, oh, we may, pirate everyone's music, but more people are listening to it. Their public policy argument was that, okay, we may have failed, but and this is what the CEO said. We pushed the broadcasters to subscription-based services that, like, for example, CBS is now going to be offering. So, what's your opinion on that? Do you think that Aereo did push CBS and these other companies towards a subscription model, or is this something that was coming eventually?
I think it was coming eventually. I mean, my understanding, the feeling I got was these models, these services were coming down the pipe. They'd been planned for some time. CBS didn't make the decision last year to do this. They didn't just start thinking about it.
Right.
They'd been thinking about it. Now, what Aereo may have done is it may have hastened the timeline some.
Maybe.
It's possible they did have some impact, but I don't think they're the reason. It's not like, oh gosh, Aereo's out there, we need to kill them and then hurry up and enter the market. I don't think that's necessarily it, because Aereo, while an interesting copyright test, was not a particularly successful in establishing the market for this type of subscription service before it was closed.
Right.
It didn't have like a huge subscriber base that was, we can't ignore this. It was modest, but it feasibly could have been profitable, I think, subscriber base. But in terms of an audience like what CBS is used to drawing and what they need to make something truly worth their time, I don't think it proved that. But yeah, it may have hastened it because they now realize they don't want other people to enter the field before them. But at the same time, I don't think they brought it about either. They may be inflating their own importance.
All right, fair enough. I don't really disagree with any of that.
Well, my question to throw out there is, you mentioned Napster, and we mentioned this briefly, I think, previous episode, but what do you think the odds are of Aereo being bought and then someone using the name to launch a legal service similar to what happened to Napster?
I think that when you're talking about brand recognition, Napster had like a year or two of just like consumer addiction. It was, everyone was doing it, everyone loved it because they were getting everything for free. And Aereo, I think, was properly dealt with early on from a marketing scheme, and public perception. The lawsuits were there immediately. It was taken as a serious threat immediately, and it was never as popular. So while Napster was largely ignored to start with and was able to bring a huge brand power to itself, I don't think Aereo has that same recognition. So I would be very surprised to see if they would be bought out. I don't think they will be. I don't think they have the same grassroots popularity that Napster had in the late 90s.
Well, Aereo said it felt it had something like $20 million in equipment and intellectual property value. So it seems to believe it has some value.
We'll see when they come out of restructuring what they actually have, and whether if that IP value is in patents, we'll have to see what those are, and because if it's in trademark value, I don't think it's.
I can't imagine a lot of that value is in the equipment. I don't think their equipment, other than like generic servers and so forth, be good for much more than creating an Aereo-like service.
Right, exactly. On Craigslist, 20 million antennas for sale.
Solder tube, single motherboard.
Exactly. Who's buying that many antennas? Well, good luck to
cell phone manufacturers, maybe.
Maybe.
I mean, I could see putting those little things in cell phones and watch TV on your phone, but that feels like a stretch.
Yeah.
The iPhone 7 now with Aereo's antennas.
Speaking of broadcasts,
yeah,
Sirius has lost another round of 372 recording.
If this were like a boxing match, someone would be like throwing the towel and trying to protect Sirius here. It's
right.
Drumming.
Well, the background of the story comes with a brief history lesson in copyright law. So before 1972, there was no federal right in a sound recording. And so
And that's because the Copyright Act of 1909, everything had to be explicitly added.
That's right.
It would only cover what was explicitly in the law, and when the law was written, sound recordings were not particularly commonplace.
No.
Movies common enough. Sound recordings, no. Apparently, that were right at the silent film era is when that law was written.
Yes, and so basically, when it comes to the public performance of a pre-'72 sound recording, which contains much of the golden age of rock and roll,
Beatles, Rolling Stones, just saying.
Is protected by a patchwork of state law when it comes to what you can and cannot do with somebody else's copywritten sound recording. And so this is another brief legal lesson. An interlocutory appeal was denied on the issue of whether these sound recordings were protected in California. I believe California, and it was granted a summary judgment was granted to the Turtles, who are well known for their "Happy Together" song,
and which was prominently featured in Ernest Goes to Camp.
Okay.
Random trivia.
I now know that. So right, the judge granted summary judgment, which is the judge will look at it. It hasn't gone to a jury yet, and the judge will say, really, when I look at this, there's really no issue of material fact, and I see the law, I see the facts, and only one party could really reasonably win this if it went in front of a jury. So I'm going to grant the Turtles basically a victory on this issue of whether these sound recordings were protected, and he said that they were. And so what Sirius wants to do is launch an interlocutory appeal, which is that I'm going to appeal this particular issue. It's not the case is over because they have a bunch of other issues, and it all goes to appellate court, and they open up the whole box, and they'll appeal 4 or 5 issues which they thought the judge may have gotten wrong or the jury may have gotten misled on, and then they'll kind of write a brief about that. This is, we want to appeal this one issue. Let's put the case on hold and not talk about damages. Let's not talk about class action certification. We just want to talk about this one issue, and so the judge denied that and said that, I don't want to let you do that. So let's continue with the rest of the issues, and you'll have your chance, your bite at the apple, which everyone has a bite at the apple. They have a constitutional right to an appeal after the rest of the case is.
Basically, they said you have to wait on this because the judge said it would do nothing but slow down the litigation, was his view on that. So,
right.
And that by itself isn't terribly uncommon, but this is pretty much the key issue in this case.
That's right.
I mean, yeah, there's other stuff like the class action status and so forth, but realistically, if Sirius XM loses on this, the rest of that stuff kind of becomes less important because they're going to wind up, paying one way or the other if they lose on that issue.
I mean, this is the big one of the biggest legal liability issues, and so if there's protection for the sound recording, I mean, they've been broadcasting sound recordings without a license for a long time, and as we've discussed before, there's damages.
Yeah.
So damages being high or low is not what you want to be facing as a defendant.
And damages, even if the damages are low per song,
right?
You have assumedly at least 3 years worth of airplay that they can go back and go through and sue over. So
that's right.
Could get very, very ugly very, very quickly, even if it's a very small amount of damages per song. And so this is a case that they don't want to lose, and I don't know if they can really afford to lose, because the full impact of it could really destroy them. They could get crushed underneath this. And it also has some very interesting implications for other services like YouTube and so forth, because one of the weird caveats about pre-1972 sound recordings being under state law is that a lot of federal laws that we take for granted have kind of weird applications if they apply at all, and one of those is, of course, the Digital Millennium Copyright Act in 1996, which is what provides the protections for hosts like YouTube. So you run into some potential legal issues there. So this is a big topic with not just drastic implications to Sirius XM, but to virtually everyone else out there too that has ever potentially played a pre-1972 sound recording on their site or service.
Yeah, I mean, these recordings have been in illegal limbo for a very, very long time.
Yeah, and
So I'd love to see this resolved, and one way or the other, at least it'll give you some sort of certainty as to the issue, so that the business models can come up.
And of course, everyone says, well, the simple solution's put them under federal protection. But it's not such a simple solution, because for courts to have jurisdiction over copyright matters in the federal court, there has to be a registration filed. And why would you file a registration for something that did not have federal copyright protection to begin with? So
it is not simple.
there is no
That's
easy
a great
answer.
example.
Unless they're going to say, okay, all these sound recordings are under federal protection, but they do not require a registration. Well, now we've created two classes of copyrighted works under federal protection, some that require and some that do not. There's just no easy answer to this. So.
And then that implicates that number of our international obligations.
Oh yeah, exactly. So there you go.
Well, I think this brings us to the Irving Azoff story.
Yeah, this one's speaking of YouTube.
Yeah, speaking of YouTube. So
had you heard of Irving Azoff before this week?
Well, of course I have.
I have lunch with him twice a week. What are you talking about?
You know who I am? Come on. I know. To be honest, I read about the company, but I didn't. And the name.
Yeah, I've heard the company too.
It documentary. They did a 3-hour. Was it 3.5 hours? It was amazing. History of the Eagles. He talks in History of the Eagles, and I'm a huge Eagles fan, so he spoke a little bit about the band's history, and he's he's a powerful figure, and so I have heard of him, but I didn't know too much about him. So he started his own company called Global Music Rights,
which has got to be the least interesting company name you can come up with.
Yeah,
well, we're going to handle music rights on a global scale. What should we call the company?
Global Music Rights. The trademark attorney in me wonders if there's a descriptiveness issue. I don't know if you really venture much in there, but generally, if you're going to start a company, it can't describe what you do, because then you basically, if you got a trademark on it, you'd have a monopoly over describing what you do as a title, when we don't want that. So, you get
a very limited copyright.
Yeah, great.
Now I'm doing it. Good God. All right, go ahead. Sorry.
Yeah, you can't exactly protect your pizza shop if you call it great.
Good pizza.
Great pizza shop, Although that almost comes to a generic issue. Anyways, we move on from trademarks, because I don't know if you're burning alive over there, going into other areas of IP, but
it's all related at some point.
Right. As long as you've always been a copyright guy, so I didn't want to bring it.
That's all right. No, I'm fine with it.
Anyway, so he represents a very exclusive list of songwriters and artists, such as Pharrell, the Eagles,
John Lennon,
some of John Lennon's stuff, and he started a company which basically was going to be a small-time competitor to ASCAP and BMI, which represent more than 95% of the songs available in the United States, which, if you think about it, is just a staggering number. Those two companies are governed by very old regulatory agreements with the U.S. government that restrict how they negotiate with outlets that use music. And so a lot of publishers recently, who through these two companies negotiate for public performance licenses and sound recording licenses, etc., have complained that these agreements have led to artificially low royalty rates paid to songwriters and artists. And so along comes somebody who feels like they have the power to start their own thing, because there's a huge barrier to entry over here, because such a huge percentage of the market is controlled.
Yeah.
So only somebody who, like Irving, who's been in the industry for 30 years, who's got connections with a good chunk of mainstream artists, was able to start this elite invite-only licensing agency, who's looking to get more money to the songwriters and to the artists, and from the licensing deals. And
he may only control 2 to 3 some odd %, but he controls a very crucial 2 to 3%.
Right, and it's a fairly new company, and so most of the deals that his clients have were done by either BMI or ASCAP. These are relatively long-term deals. So those agreements are expiring over the next few years. So I think we're going to see the impact of this, third player come in, and I think it's going to be a good thing for artists and songwriters. As long as they can get a deal done, because we don't want these songs disappearing from, online services and radio stations if these deals aren't made. But if the deals are made and a little bit more money goes the way of artists and songwriters, I think it could be a good thing. And you're seeing that starting because obviously Google didn't have a deal in place here, and so you're going to see that being pulled, and we're going to see the private market do what it does, which is we take it out, and then until somebody misses it, and then you come to a settlement, just like any other business.
But the reason we're talking about them right now is because we talked about YouTube Music Key, the new music streaming service.
Right.
Well, apparently, according to Azov, YouTube did not secure the rights from him for his stable for this new service. And so he is demanding that 20,000 tracks, is what the estimate I keep seeing, be removed from YouTube and from YouTube Music Key because they don't have the proper licenses from them. He says he has no evidence they've received a proper license. Now, this seems like a pretty, I don't want to say rookie mistake, but you know what I mean? It seems like a pretty simple mistake for you to be making launching such a big service like this. To leave out, admittedly, like I said, not one of the big players, not an ASCAP or a BMI, but still a pretty significant player in terms of star power.
Right. I mean, a lot of these, most of these catalogs are exactly that. They're licensed by catalog, so you're getting, you're not like you're not going to individual bands and saying like, hey, we'd love to have you on our site. It's all run by ASCAP and BMI, which is where the event
and a little bit of CSAC too, I think.
Yeah, a little bit of a devaluing of individual artists. So they probably there was an oversight as to what their catalog payment, their licensing payments for catalog entailed, and obviously they missed the boat on this one. So we'll see where it goes from here to see if I'm sure they're going to come to a deal. There's no reason to.
Oh yeah.
So you'll see a settlement here and a license fee paid.
Absolutely, and obviously the other side of it is since we don't know the contracts, we don't know who signed what, when, and what it said, we can't determine who's right or wrong. From our point of view, we have no way of doing that. So it's just a situation of these two sides are going to have to work it out. And I'm like you, I'm about 100% sure we're not actually going to see this music disappear.
100%. This will be worked out, and
it's too much money to be made by both sides to not work it out.
And hopefully this new company will be able to bring a little bit more money. Although obviously these mainstream artists aren't exactly starved for songwriting fees, but it's hopefully it'll trickle down.
Yeah, and it's interesting because there's been a lot of talk about reforming those consent decrees that impact ASCAP and BMI too. So this could help motivate that process along a little bit too.
I don't see that happening for a long time.
It's still the department. They're done by the Department of Justice, so I don't know.
That's right.
I guess we'll see.
So, for those who don't know, a consent decree is basically you're resolving a dispute between two parties, and neither one of them, admits that they did anything wrong. It's almost like a settlement, but it's done. In this case, for antitrust issues.
Mm-hmm. And it's interesting because here in New Orleans, consent decrees are in the news a lot because the city of New Orleans actually subjected itself to 2 consent decrees centering around its police force and its jail with the Department of Justice. So similar deal there, but different topic area. It's settlement-ish is the way to think of it.
That's a different, an interesting way to do it. So, maybe we should just go to the final step. Antitrust is basically legislation that prevents monopolies. It's regulation to make sure that you can't set.
You can't abuse your monopoly status, basically.
Exactly.
To destroy the market and make orphans starve and make and kick kittens and stuff. You can't do that if you have a monopoly.
Right. Because once you have a monopoly, you tend to abuse the marketplace. So that's what an antitrust decree does. It basically governs the regulation in which you are allowed to retain a monopoly.
Yep, bingo. Well, I've got to say, you know, Perfect 10. In copyright circles, every year I have to redo this joke, but I think they're safe to call them the Raiders of the copyright world.
The Raiders.
The Oakland Raiders here of the copyright world. They are
Yeah, they're very
uh,
litigious and not very successful.
not very successful at all. They're losing. Every time I seem to see Perfect 10 come up in a copyright news story, they're on the wrong end of
Well,
the.
they have their integrity at least. They're pornographic in integrity.
They are very, 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 very litigious company, and they never seem to win. It's what way it appears. And here they're losing again. This time to Giga News, which is a site that I don't fully understand, I admit, but apparently it's like a web interface for Usenet because you couldn't just use the web or use Usenet. You had to anyway. It's that type of service. And Perfect 10 said a lot of its content was appearing on Giga News. So it sent what it felt was compliant DMCA takedown notices,
Right.
and the court seems to disagree about whether or not those DMCA notices were compliant. This resulted in Perfect 10 suing for just about literally the entire slate of what you can sue for in copyright infringement.
Right.
I don't think they left a stone unturned.
They sent DMCA takedown requests saying, and this is the quote I found, please conduct searches of specific names within certain news groups and remove all results that were returned on a certain date. So they basically said, you know, please search for, Jessica Doe, within these 6 news groups, and from July 10th to this brand, take them all down. So it's like do it yourself, basically, is what they
Mm-hmm.
say.
Trying
Which,
to sort of ad hoc filtering, if you will.
yeah, and that's not how the DMCA works. A lot of litigants have learned this, is that you need to be extremely specific, and as hard as it may be, you need to say, this is the infringing file. We found it at this URL, and this, obviously it may not be a URL, maybe, it's a subtopic or something like that. We own the copyright in this. This is your notice to take it down. You have to be specific. You have to go to specific files, or otherwise, when you get to litigation, you're gonna lose. And that's what happened here.
And
Because
I take it a step further when I file over TextWorks online. I actually provide a report showing the text highlighted and side by side. This is the text involved. These are the exact paragraphs. Take this down.
that's right.
So,
And so the DMCA basically offers it was a huge piece of legislation, but what we're talking about now is the takedown system, which is it provides insulation from direct copyright liability. From secondary copyright liability. If third parties are uploading content onto your servers that someone else owns, it's this takedown system in which you have to offer a way to get in touch with you in order for a copyright owner to tell you that, hey, please, someone else uploaded this item onto your website, I own it, take it down. And so if you have a service that runs reasonably well, you can't be liable for hosting or reproducing or basically
works uploaded by third parties.
exactly copyrighted material.
Yeah, and it's overall served the internet, I think, pretty well. It's made sites like YouTube possible because without that legal certainty, there was no way there could have been a YouTube. I mean, imagine if YouTube had, in the early days especially, been forced to automatically detect and filter every copyright infringing work. It just never would have happened.
Right.
It never could have happened. But yeah, Perfect 10, realistically, this is kind of a lengthy story here. Now, they tried to sue not just for a secondary liability, but also for direct copyright infringement, which did not work. The court just found no evidence that Giga News had done anything possibly remotely related to direct copyright infringement.
That's right. Excuse me. Either if their employees were doing it, or there was no evidence of that. You have some cases where employees are like favoriting and they know about videos, or they're uploading it themselves.
Like what happened with Group Shark, actually.
Exactly. And so they didn't find that in this case.
No. And it would be very stupid of Giga News to do that, and it'd be very stupid of Grooveshark to do it, but one of those two companies is apparently smarter than the other. Is what we've learned in the past few months of copyright news. But yeah, they sued for direct, that didn't go anywhere. They sued for secondary, and that didn't go anywhere because they found the DMCA notices to be inadequate. So, another big loss for Giga
Also
News.
didn't find that there was enough of a financial benefit, which is something you need for a form of secondary liability called vicarious copyright liability, which
I forgot about vicarious, yeah.
If you basically have, there's a two-pronged test. If you have the right and ability to supervise and promote the people who are uploading the content, which in this case may be the users, you've got the ability to figure out what your users are doing, and then your secondary, you're getting a direct financial benefit from what they're doing, you can be found liable for vicarious liability, which is something. I mean, it's the same legal principle of if a driver of UPS does something bad to me, I could sue UPS. It's something like that. But yeah, you were going to get onto our Kim Dotcom story.
Yeah, we got our stories. It's plural. We have two Kim Dotcom stories. Yeah, because Kim Dotcom had a bit of a rough week. Let's just be honest. He's had a rough few weeks. I mean, his attorneys have bailed on him, which...
He's had a rough few years, let's be honest.
Well, but it's gotten even worse. Ever since he lost that election, things have just consistently gone further downhill for him. But the first one is what's going on in his home of New Zealand, and that is he has had some very, very difficult new restrictions placed on him. He is not allowed to travel by helicopter anymore.
Oh, no.
Oh, woe is me. He's also largely confined to his mansion and 80 kilometers of his mansion.
Well, it's a rental mansion.
It's rental mansion, yes, okay, fair. Which I also go, woe is me. However, does he survive and not being able to go more than about, I think, 40 miles from his rented mansion. And he has to check in with a local police station every day. Now, this is pending a hearing on his bail, basically. He's out on bail still and has been for years, but according to the prosecutor, he has violated the terms of his bail repeatedly, and they're having a hearing on it next week, and it may actually be revoked or have further restrictions placed on it. These restrictions could become permanent or new ones could be tacked on. So...
Yeah, well, it sucks. I don't know anything else to say about it.
There's not much to say. I mean, it's really it is what it is. But yeah, it's just, I have a hard time drumming up significant sympathy for Kim Dotcom's plight in this front.
Yeah, well, eventually I hope that someone does the time and then is able to get on with his life. If depending how long, obviously, his sentence ends up being, but seems like many years of limbo.
Yeah, and some of it, and there's going to be more limbo now because with his attorneys leaving. His hearing, which was for February 2015, got pushed back to June next year.
That's right.
And to put this in perspective, the raid and the arrest and all that jazz went down January 2012. I mean,
well, when you're fighting extradition, it's not going to be a short road.
No, it is not a short road. And speaking of fighting extradition, that's giving him some problems on the United States side. The United States prosecutors, the Department of Justice here, has filed a civil suit, which is one of those those civil forfeiture things taking place, saying that basically they want to keep the money and other stuff that they have already seized. They want to hang on to it forevers, because they believe it is unlawful and gained in the process of a crime.
Right.
And Kim Dotcom attempted to say, hey, wait a minute, I'm going to fight this. To which the U.S. government says, "Oh, I'm sorry, you can't do that. You're technically a fugitive."
That's right. And I actually had to look up this because I've never done much study of criminal law past my first year of law school. But like you said, a number of assets were seized in the like of houses, cars, and big televisions when the mega video indictment was unleashed, and so now they've filed to make this instead of a seizure of an asset, a taking of the asset, and he is trying to fight that in U.S. courts despite fighting extradition to U.S. courts. So he has a legal team out there saying, trying to argue that there is no criminal copyright infringement for secondary liability, which is what he's basically accused of for running Mega Video, which had third parties, individual users upload all of the infringing content, and he filed a motion to fight against this takings, and the U.S. government responded by moving to strike the motion, which means that basically they're moving to court to not hear the motion from a procedural perspective, not even look at its substance, because of a concept called fugitive disentitlement, which bars someone from, quote, using the resources of the court if they are fighting extradition or invading arrest, which is an odd concept to me. Personally, I think that you should always have the right to have your case heard regardless of whether you've been arrested yet. It keeps the dialogue channels open, and it seems to be a very odd and broad word, using the resources of the court. But I could definitely see situations in which it would make sense, where the fugitive is particularly heinous, but at the same time, I always think that you should be able to have a procedural right before a court. I don't know. This one strikes me as strange.
It strikes me as strange because the impression I got was the intent of the law was to keep you from hiding out and evading arrest, and then fighting your case without subjecting yourself. But Kim Dotcom isn't necessarily evading arrest. He's not on the lam per se.
Right.
He's merely using legal maneuvers in New Zealand to fight extradition.
Right.
That is it. He has not gone into hiding. He is not hiding in a cave in the mountains of New Zealand or anything. He is not
Osama bin Laden.
He's not Osama bin Laden, the New Zealand's version of Osama bin Laden. His whereabouts are known. He is using, like I said, his lawyers and his legal team to fight extradition, which he has the right to do. So are you saying by him exercising his right to fight extradition, he loses his legal right to fight the civil case? And that's
what they're saying. They're saying that if if you were arrested, of course you'd have all your procedural due process rights, but for some reason there's this I'm sure it's for extreme cases, and it's a discretionary grant by a judge, which means that he does not have to do it, even if the Justice Department asks him to do it. So we'll see what the ruling is ultimately, but it is a discretionary grant, and we'll see if they're going to strike his motion. I doubt they will. I think they're probably just going to hear it and then deny it. That's the same.
Yeah, I think that's what's going to happen too. And one of the issues is he's not just being charged with criminal copyright infringement, which he actually isn't being charged with, I don't think, but he's also being charged with money laundering and other things as well.
That's right.
There are other criminal allegations on the docket against him, so they have other things they can attach to it. And my understanding of these civil forfeitures is, and granted, my understanding is completely limited to John Oliver's spiel on it. So I've got like 15 minutes.
John? I'm losing you.
Has to prove.
John?
I'm coming back now.
Oh, you're back.
Okay. I'm back. Yeah, I think so.
All right, there we go.
All right. Well, yeah, my understanding of civil forfeiture rules is that the burden of proof is flipped here. Kim Dotcom has more of an obligation to prove that the money and the assets were not gained as part of a crime, as opposed to what you would normally expect, where the government has to prove its case.
Right. In any civil case, the preponderance of the evidence generally shifts. I mean, there's a lot of exceptions, but in a criminal case, you have to prove everything that you want to prove beyond a reasonable doubt, and then in a civil case, it's a preponderance of the evidence standard in most cases.
Exactly. So I guess we will see what the court decides. Unlike you, though, I think they're going to hear it and then just deny it, and that'll be the end of that.
I think this whole thing is drawn out as an excellent deterrent case, which is that this is going to be long and hard for this person because we don't want anyone else running piracy sites from overseas.
Yeah, we don't want there to be Kim Dotcom too.
Right, which of course there's Kim Dotcom 2 through 100, unfortunately, but
I'm sure there is, yeah. But
but
we haven't seen anyone come to that level. You know what I mean?
Right.
We haven't seen anyone have their own ostriches on their rented mansion in New Zealand based upon building a pirate-friendly site. We haven't gotten that far. Well, finally ending it on a obscure act that we almost never talk about, the Audio Home Recording Act, the AHRA. It sounds like a drag racing organization, American Hot Rod Association, I think it is. But hey, wait a minute, that is the same acronym, American Hot Rod Association. I was right.
Oh no.
Oh no. And
you brought that to their attention.
But this AHRA has a very different implication for car makers, in that it is being used now to sue 2 more car makers. It is Chrysler and who's the other one? I think it was those random ones. I forget. But
yeah,
it was Chrysler and Mitsubishi.
So under the AHRA, importers and manufacturers pay royalties on any digital audio recording devices and digital audio recording media. So anybody who wants to import, manufacture, distribute that type of item has to seek a statutory license from the Copyright Office, which means that there's a preset amount you have to pay per import, per manufacturer, per item that you're manufacturing, and then royalties are based on this little price. Which is usually either how much you're going to sell the item for or what the market has set for the item. And this was passed in '92 because of the uproar about the ability to burn songs, and so they figured the best person to pay for this would be the manufacturer and the importer, and so that way this money will go towards all the songs registered at the Copyright Office. And so, because if they're eventually used to, burn illegal copies, at least some money will end up in the pocket of and the artists, exactly.
But the law suffered something of an incredible setback a few years afterward when it was ruled that MP3 players didn't qualify for it.
That's right.
And when that happened, pretty much no one paid anything anymore, because it came to fall under such a narrow amount of manufactured media that it really wasn't applicable. In fact, it's one of the reasons why if you go to a store, you will see burnable CDs intended for data and intended for music. They will label it. It's the exact same DVD, exact same burnable content, burnable CD, but the royalties have to get paid on the music ones, the ones intended for music.
That's right. And right now we're dealing with a MyGig and Uconnect Media Center, and I don't own any one of these systems.
I do not own nearly a nice enough vehicle for this.
Yeah, but I imagine and this is what I read, is that it's your basic, put your CDs into your car, and then it'll
store in a little internal hard drive.
And give you an internal hard drive. And Chrysler and Mitsubishi decided not to pay this fee per item that they manufactured or imported, and eventually got a demand letter from the artists' representatives, and they decided to look it over and see if this was a real claim, and probably send it to a lawyer to figure out, like, hey, does this qualify under the AHRA? And then eventually things weren't progressing fast enough, and so we're going to see things litigated.
Yeah, and what's interesting about it, like I said, there was a previous lawsuit against Ford and GM that's already underway, as you said, and it's fascinating because this group, even though it's the Alliance of Artists and Recording Companies, the AARC, which also sounds like it stands for something else, so I can't quite figure out why. But they represent, the 300,000 artists.
The Retired People's Association.
ARP is that's what I'm thinking of. ARP, yeah. But the thing about it is, despite that, because of the nature of the organization and what it protects, they only handle a few $1 million worth of royalties every year. And that sounds like a lot, but
No.
in this space, I mean, considering that Spotify alone pays over 500 million in royalties, per year, stuff like what I've heard. Um, yeah, it's nothing. And that's just one company.
Yeah,
So
it's not very much, but we'll see
I mean, this
where it
could
goes.
expand that drastically if these are found to be underneath the covenant underneath the law.
I think it'll probably just discourage most automakers from giving these databases because like this is like a short period as to when like I guess their market was the older clientele that still has a big CD base and
Mm-hmm.
they want to put it in their car. Everything is this is just I think a short window. It's going to move towards getting Spotify and
And
Pandora
of
in your
course, we've already
car.
discussed MP3 players aren't covered, so
Yeah,
we're back.
yeah.
Back to square one. But yeah, I think we're going to be moving to a Spotify, Pandora, maybe not those companies, but that style of music universe.
Yeah, it's gonna go. It's gonna be all radio, and then it's gonna be all streaming, and then the hard drives will find their way out.
Yeah, I think that's pretty much it. We're already seeing, computers shipping with minuscule hard drives in general because everything's cloud-based and web-based. It's not just music this is happening to.
Right.
And you can go right now buy like a $200 Chromebook with a hard drive that seems anemic by even standards, 10 years ago, and make it a perfectly functional computer as long as you're connected to the internet.
Right.
Well, that's all the copyright news fit to print for me. You got anything else to add? You heard, overheard? Any?
You know what? I never got to ask you about how the haunted house worked out.
Oh, it went quite well actually. We did a really good job. We had about 400 people come through, most of it on Halloween night. And really, really good scares. Ran a really good line the whole time, and just it was a lot of fun. I mean, I think everyone had a great time. We were a little bit down for the season because our Saturday was after Halloween, and that didn't really go so good. Usually
Right.
we have kind of two big nights. We only had one big night this year, but still had a great time. Everyone enjoyed it, and we're gearing up already for next year, which is our 10-year anniversary.
That's great. I guess on my end, I'm going to be checking out a living room tour event tonight, which is a
Oh,
really interesting concept that started here in DC, which is that um, basically it's they organize tours for local artists, but it's not the traditional tour. They're not going around the country. These are small, up and coming local DC artists that
hmm.
are going to be touring living rooms in DC. So they'll be playing 6 or 7 different gigs at random parties in throughout the district area. So I think it's a really interesting grassroots project for music, and so I'm interested to go check them out, and maybe I'll be able to help them with a few legal issues. And so
That sounds really cool. It's like a neat idea. I wonder if they could do something like that here. I go to a lot of open mic and jam events here in New Orleans. I'm usually at one or two a week, and I love it. And that small intimate environment's a really great way to listen to music, and it's really great to have an environment where you can talk to the musicians. You can, you know what I mean,
yep.
actually interact with them other than heckling. Um, and productive interaction with them. I really love that. That's a really cool idea.
Yep. I'll let you know how it goes.
Yeah, definitely. People always ask, what do haunters do for Christmas? Well, it turns out a haunt in Mississippi that I kind of help at sometimes. We'll be doing a haunted Christmas thing. So I will be
Well,
helping out with that and acting in that too. So I'll have more on that as we get closer. And I don't know the exact dates, but they're still getting set up that way.
there is the Raising of the Dead theme common to both
Yes.
holidays.
Mm-hmm.
Let's see what else.
Let's face it, Santa is creepy. There's just no way around it. The idea of Santa, an old guy that watches you constantly, is very creepy.
A little bit, and when it comes, I think you can find a way to associate Halloween with all the holidays. You got, the Hanukkah miracle of lights, and you got the Roman theme. It's all Roman times, and
Mhm.
you got your costume there that makes sense for Hanukkah, and I can't say I know enough about Kwanzaa to make the analogy, but
Yeah.
I'll have to do some research there.
But it's fascinating how easily you can apply. Every holiday has its dark side, is what it comes down to. Because Halloween's open about it.
Yeah.
Well,
All right. Well, it's been great,
on,
and I'll see you next week.
well, on that note, my name is Jonathan Bailey from the site Plagiarism Today, which can be found at plagiarismtoday.com, and I'm username Plagiarism Today, spelled there for the people that don't know how to spell plagiarism, on all the sites, Facebook, Twitter, Google+, etc.
PLH. Okay. My name is Evan Ferris, and you can find me on Twitter
At Evan Cherez.
at Evan Ferris. And I'll see you next week.
See you next week, man. Have a great week.